Again, just like to welcome you all to Contract Manuals 2021 update, the basics of contract review from an insurance perspective. This is part 1. Again, we're going to do part 2 and part 3 on Wednesday and Thursday of this particular week. Our presenter is Nancy Droughton, Vice President of Marsh. Nancy is an attorney and a senior consultant in the contract review division within Marsh's complex liability consulting group. In this role, she provides contract review consulting services to Marsh clients, ensuring that contracts and the client executes align with their current insurance program and risk transfer preferences. So she is the person that we need to talk to. With that said, Nancy, are you ready to fly?
Thank you, and thank you everyone for putting up with my technical difficulties. I apologize. Well, Dan, thank you again. I'm Nancy Droughton. I'm with Marsh, as was previously explained. Our topic today is going to be one of 3 days and 3 parts worth about contract review, specifically the insurance requirements in contracts. I know it's a little bit unusual. This is not something people think of as a particularly glamorous topic, but it's an important topic, and it's actually what I am quite passionate about. So I'm happy to answer your questions as you have them. Do not have, feel free to interrupt me as I go along. You'll find that these insurance requirements are critical. It's critical to understand them, and more importantly, to have them negotiated and understand what you're agreeing to prior to signing your contract, because after the contract's executed, you're kind of locked into sometimes insurance requirements that you're not able to satisfy, and that's not necessarily a good situation. So if you take nothing else away from today, that's your big takeaway point, is make sure that you do look at the insurance provisions while you're in the negotiation phase. Maybe don't save it as the last item on the list to negotiate, and be confident and comfortable that you understand your insurance program enough that what you're agreeing to, the program will in fact cover. So in a nutshell, that is what we're going to be covering today. And let's get started. I just told you what we were going to be studying. Here's how the 3 days will break down. We're going to talk about contract review and some of the insurance requirements today. We're going to talk about how to perform a contract review and some of the distinctions between when the local government is asked to provide insurance. We would call that an incoming requirement. So the other party saying, local government, these are the insurance requirements we want you to provide. And then the other side of that coin, and you'll see you probably deal with these a good bit, is when you or the local government are imposing the insurance requirements on another party. Perhaps it's a consultant or a vendor or contractor. So that it's not exactly the same review, but it's very important that either one of these are addressed. As far as when you, the local government, are providing insurance or requiring insurance on your vendor or consultant, there's some templates that will be in the contract manual that should be very helpful and make it a little bit easier and streamlined for you in the future. And then on the last day, we're going to talk about certificate of insurance and best practices and some tips and tricks that will help you in your reviews. So why is a contract review even important? As I mentioned, there's 2 different perspectives. There's the perspective of when you, the local government, are having to satisfy insurance requirements. And then there's the second perspective, is when you're asking another party to meet the insurance requirements. Their insurance would be perhaps covering you, and then that's an additional insured, and we'll get to that term and some more specifics about that. But primarily what we're going to focus on throughout these next 3 days is when you, the local government, are being asked to provide insurance requirements. Somebody else says, this is what we want you to have, and and you need to vet that and make sure that your insurance will satisfy those requirements. So one of the importance is that in It allows for a coordination between the indemnification and insurance sections, 2 sections of the contract where risk transfer is provided or accounted for, and you want to make sure that they align, because the best result is that your insurance will cover most of your indemnity obligations. You want to appropriately allocate the risk between the parties. I mean, most people, if you're being the one to put up your insurance, somebody thinks that there's some risk with you being involved, and they're going to ask for you to provide additional insured coverage for that other party. And that means you're making your insurance program available to them. So you want to be very careful about that and make sure that you understand what that means and how much money that could potentially be, things such as that. It can affect the bottom line. If you have uninsured, retained, or increased losses, it can have a big impact on your budgeting. So those are some of the reasons that you want to do that. Being able to efficiently understand and review your insurance requirements in the contract will assist in your relationships with other contracting parties. It's going to affect your ability to manage your insurance program. And importantly, it will help avoid breach of contract, perhaps penalties and fines. It helps you identify retained and transferred risks, the risks that you put on the other party versus the ones you're keeping for yourself. So all of these are particular reasons why you do want to pay attention to that insurance clause, which has probably been overlooked in the past. We're going to take it back to the basics here. You know, what is a contract? We contract all day long, regularly in our personal lives and in business. So contract is a deliberate engagement between competent parties with legal consideration to do or not do something. And contracts can be written or oral, implied, express. And a good example of an implied contract, because I think that's something that we kind of get stumbled on, is perhaps you take all of your tax paperwork in February, say, and drop it off at the local accountant's office. You haven't spoken to the accountant, you haven't signed any paperwork with the accountant, but there is an implication that you're hiring that accountant to provide the service of preparing your tax papers that year. So that's an implied contract. Oral contracts, you can contract, not all contracts are enforceable if they're verbal. Many require to be in writing, and obviously the best practice would put contracts, your contractual terms in writing. Like that does not always happen, but know that you can have an oral or a written contract, and then the express contract just has specific terms. Note at the bottom, this last bullet, we're going to talk about different endorsements, which are basically additional terms, exclusions, or conditions added to an insurance policy. An insurance policy is a giant contract, by the way. And many of these endorsements require written contracts. So that's going to be something you want to be aware of if you're providing or asked to provide a type of insurance coverage that is offered by endorsement. You want to make sure that if it does, the endorsement requires a written contract, that there is in fact a written contract. And some of the standard endorsements, and I will get into this a little bit later, so I know I'm throwing out some terminology here that may or may not be familiar with you. If it's not, stop me, we can talk about it specifically. If not, we will get into those details. But additional insured coverage is often written or drafted where a written contract is required. Waiver of subrogation can also require a written contract. Primary and non-contributory. Those are 3 types of endorsements that we often see on casualty policies and that are often requested in contracts. Here's just a short list of different types of contracts. I'm sure you're familiar with many of these. So back to the contract, as I said, back up. So there's 4 parts to a contract. There's an offer and acceptance. So you have to have an agreement between the parties. There's got to be a legal purpose. You must have consideration, which is generally a promise or an exchange for one person to do something, and maybe a monetary consideration for goods or services. And you must have legal capacity. That means your legal age and appropriate mental capacity. And then back to that some contracts must be properly signed and dated to be binding. That gets a little deeper than we need to, but insurance contracts are always in writing. There are several contractual terms that
Hey,
you will.
Nancy,
Yes.
I got a question from someone.
Okay.
What is an endorsement in the insurance context?
It's a very good question. An endorsement is added terms, conditions, and maybe even an exclusion to the standard insurance policy. So you generally have a standard insurance policy that outlines what it will cover or not. And then I guess you could think of it almost kind of like adding to a Lego building. You can add or subtract different parts of your standard coverages by using endorsements. And it's basically an add-on to the policy. It becomes part of the policy, as a matter of fact. And then the endorsement could include, maybe it offers additional insured coverage. It may be an exclusion where it's saying we are not going to cover pollution liability under this insurance policy. So it's just, it's more pieces to the policy that adds or takes away different coverages from the primary insurance policy. Does that make sense?
Yes.
Okay, good. Other insurance is a risk transfer device. Other contractual risk transfer devices are hold harmless and indemnification clauses. These are typically something when we're reviewing contracts for clients that we will take a peek at, but we do not make recommended changes to because they're more of a legal nature than an insurance nature. But we do want to make sure that there's an alignment there that the insurance will support the indemnification and hold harmless clauses. So hopefully you've got somebody on your team that can review those more legal specifics on your contract. So again, that these clauses exist. Some of the things that, like I said, where we're looking at things that a contract and looking at the hold harmless and indemnity clause and then the insurance coverage, the bottom part is probably the most important part of this slide, that the examples of things that insurance will not cover: breach of contract, the sole negligence, gross negligence, willful wanton misconduct of another party, a requirement to cover any and all injuries or injuries and losses arising out of or in any way related to the contract. The third bullet is really broad language, any and all arising out of, where you're talking about maybe behavior of the other party to your contract. Insurance is, and you probably have seen this in your homeowners or auto policy, you know, it's a lot of terminology that says, first we're going to insure a whole broad spectrum, and then there's a long list of exclusions, things that will not be covered. So wording such as any and all is just overly broad. An insurance policy will never be as broad as any and all. A big part of that policy is going to be a laundry list of exclusions, so you can count that any and all would not be covered. You would want to strike that. Sole negligence, gross negligence of the other party is not going to be covered even under additional insured endorsements, because that party should be responsible for their own behavior. It's not like it's linked to the local government or anything that you have control over. And then breach of contract is breach of contract. That's not covered by an insurance, the insurance policy either. And here's some Georgia specific information that's been shared with me, and I believe we have somebody that can help speak to these.
Sure. This is James. I practice here in Georgia, and from time to time we get questions about cities in my practice, and I know county attorneys do, signing indemnification agreements when they're in contracts with other parties. And there's some case law that provides some clarification on what cities and presumably counties can and can't do. There's this case called CSX Transportation versus Garden City. It's a 2003 case that actually was a federal case that went through the district court up through the Court of Appeals and came over to the Supreme Court of Georgia on a certified question. The facts of the case were that the city of Garden City needed to do some work out in the right of way next to the railroad. And in order to do the work, they had to get permission from CSX Transportation, and CSX required the city to sign an indemnification agreement. An accident happened and CSX was sued and turned around and tried to seek enforcement of the indemnification clause against Garden City. And Garden City was a GRMA insured in our pool, and GRMA Defense Counsel came in and challenged the legality of the indemnification clause. Under the Georgia Constitution, cities and counties have sovereign immunity unless it's waived specifically by the legislature. And the lawyers for the city argued that it was not permissible for a city to waive its sovereign immunity by contract like that. And when it went to the Supreme Court of Georgia, the Supreme Court of Georgia agreed. They said that because only the legislature can authorize the waiver of sovereign immunity, a city could not just enter into a contractual indemnification agreement and waive its immunity like that. So the clause was held to be ultra virus and beyond the power of the city, and therefore unenforceable. This is informative for cities and counties, because counties derive their sovereign immunity from the same portion of the current Georgia Constitution. So presumably neither a city or county would be able to agree to indemnify a private party. And this is helpful because in most of these situations, the other party wants the city or county to, sign a mutual clause or seek indemnification from the local government. It's just not permitted. The one exception that we know of is where you have cities and counties who are seeking indemnification with respect to each other. We had a case that came out 2 years ago called College Park versus Clayton County. College Park is a city located partially within Clayton County, and the litigation had to do with collection and division of tax receipts. And in that case, it didn't really deal with an indemnification clause, but it dealt with the question of whether a city could sue a county because they're both sovereign under Georgia law. This case too went all the way to the Georgia Supreme Court, and the court held that yes, they are sovereigns, but they're not sovereign with respect to each other. So local governments can sue each other, and they're not subject to sovereign immunity. So theoretically, the holding of CSX would not apply in the situation where you had a city or county trying to seek indemnification by contract from the other. And when you have an intergovernmental contract, the cities and counties would enter into for various kinds of services or multi-jurisdictional agreements, task forces, and so forth, you would be able to presumably have an indemnification clause. This would not prohibit having a clause in the contract that requires one party to provide insurance for the other. Thanks.
I think there's one more slide.
This is some specific Georgia law that comes up in the context of indemnification agreements. And what it basically says is when one party, whether it's a local government or any other party, can require indemnification from the other, and what types of indemnification agreements are prohibited by public policy in Georgia. And basically, if it's an indemnification clause relative to construction, moving, demolition, or excavation of a building structure, basically construction type agreements, you cannot have indemnification based on the sole negligence of the indemnity. So if the party who didn't screw up cannot be held to indemnify the other party if they were solely negligent, which means you can have a clause that's partial that says that each party will indemnify the other for their own negligence. And that's basically what that second subsection says. You basically can have indemnification as long as it's a restricted indemnification provision. And both of these code sections allow for parties to require contract from the other party, even if it's one of the types of contracts that are described in these subsections of the statute.
Thank you.
Thanks.
Another contractual risk transfer device that's used in contracts is a limitation of liability. And that's a clause where they're trying to maybe put a monetary limit or something to restrict the liability of one party to the other. And you'll see it quite a bit. You maybe see if local government is providing the insurance in the agreement, which is primarily our topic today, may use a limitation of liability to add a cap to a specific amount. And you would not want to carve out insurance or indemnity requirements there, because the cap and the limitation of liability will also lap to serve as a cap also for the insurance requirements, the insurance limits. However, if the contract is local government asking its consultants, contractors, or vendors to provide the insurance, then you want to avoid using the limitation of liability. And if you use one or the other party insists on one, you do want to carve out insurance and indemnity requirements, because that limitation of liability cap, which is usually a dollar amount or so many times the contract value, will also serve to put a cap on the insurance limits that may be available. It kind of trumps whatever you put in the insurance clause. So that's something to remember, and you need to think about it from how the contract is drafted. For today, we're going to primarily be discussing if local government is providing the insurance requirements. So we would then want to have the cap on damages and with no carve out for insurance or indemnity. So these will probably be different types of insurance that you've used to seeing in contracts. General liability, also called commercial general liability, is the third-party coverage for premises of bodily injury, property damage. Commercial auto is the coverage for when vehicles are used under a contract. Workers' compensation and employer's liability. I think you're probably familiar with workers' compensation. Employer's liability is also a part of a workers' compensation policy. And that coverage is just all together in one. You often see umbrella excess liability requirements. That umbrella excess policy will provide additional limits and coverage to the commercial general liability, the primary commercial general liability, the primary auto liability, and the primary employer's liability. It does not affect the workers' compensation side of that policy, just the employer's liability coverage under that policy. And then professional liability is often requested, if you're dealing with accountants, attorneys, other types of folks providing professional services. You'll also see technology, errors and omissions, and professional liability if you're hiring somebody for some sort of technical project. You have quasi-professionals, real estate brokers, consultants. All of these you would want to ask for professional liability coverage. The state of Georgia, I doubt that y'all have professional liability coverage specific to your local governments, but perhaps you do. I don't know if y'all get into that arena. Some other commonly requested types of coverages is property insurance. That's a first-party coverage. That means your property insurance will cover your property, not third-party property. That third-party property damage is covered under the commercial general liability policy. Cyber liability, which is becoming harder and harder to obtain, but is becoming more and more important in certain aspects of our society and how we have all transitioned more into a technology-based commerce society than we were before COVID. Pollution liability and builder's risk, which I don't think is going to be applicable for y'all. This is a very general introduction. Is there any particular questions on any of these coverages before we dive deeper?
I have a question here. When contracting with a third party which wants to require indemnification of the city, can a city rely on unenforceability of the indemnity, or could that be considered bad faith?
I think that's a James question because that's Georgia specific.
Sure, I don't think it's I don't think it's necessarily bad faith, but we don't typically like to have cities enter into agreements that they know they can't enforce. What we typically do is at least call it to the attention of the other party or insert some language in the clause that says to the extent permitted by law. So at least, you know, there's some clarification as to that. But, you know, both parties can have their own attorneys and presumably they would be charged with knowledge of the law. But it is better to go ahead and put some language in there to sort of hedge that obligation and have a discussion with the other party about it. A lot of times we have cities that you'll have parties they contract with who try to require indemnification, and we go back and show them the CSX decision, and they'll back off. But the second question you're going to get is, well, then you need to provide, you know, coverage to us as an additional insured on your policy, because that is permitted. So that's what you're going to get. We don't like to do that in our pool if we can, you know, and I don't know with the ACCG and GRMA, there's an open question as to whether either of these pools can actually insure a private party like that within the enabling legislation. And a lot of times we make a pretty good argument and even can get out of having to do that. But sometimes if it's somebody like Georgia Power or a pretty serious player with significant bargaining power on the other side that you don't have any way not to contract with them, they may be able to enforce it. And then you just put that limiting language in there. The other thing I would say is in all situations where you can do it, you need to require that the other party name the city or county as an additional insured on its coverage and make that coverage primary to the city or county, so that neither GRMA nor ACC-IRMA have to come in and be primary on that loss. And that's always something that we like to recommend. I gave you a fuller answer than you wanted, but there you go.
And towards that comment, though,
Before you move on, Nancy, one more question. Are there standard limits on each coverage that are recommended, or would it be a project specific?
That's a kind of, the answer to that question is both. So there are standard limits that we typically recommend. It's where the discretion falls based on what the project or scope of work is what the limit might be required under the umbrella excess. And so typically when we're proposing insurance requirements or helping somebody draft them, we will ask that the other party provide $1 million per occurrence and $2 million in the aggregate commercial general liability, usually $1 million on the auto, the workers' compensation, and according to statute, whatever's required by law, and employer's liability, about usually we ask for $1 million coverage. And all of those limits, except for those statutory workers' comp, now have an umbrella excess policy that would be over that. And that's where you can ask for additional limits. For something that's low risk, we would suggest asking for $1 million, maybe a medium risk $5 million, and a high risk 10 or more $1 million. I mean, I've worked on projects where it's been several $100 million because they're enormous real estate construction projects. So it does vary based on what the scope of work is. But a good point, and something to reiterate here, the reason why we're dividing those limits between the primary commercial general liability, the auto, and the employer's liability, and then asking for an umbrella excess on top of that, is because we want, if there's a catastrophic loss or something that's large, we wouldn't want you to be limited to collect only on the primary policy. So now you have the ability to access their umbrella excess policies. And there's other wordings that you can use, such as asking for a minimum of $1 million per occurrence and a minimum of $2 million in the general aggregate. That type of wording could allow you to get into their full insurance tower of limits. So many companies have the primary layers, and they're usually not high limits. And then they have several layers of umbrella excess coverage on top of that, which could be the first layer maybe $5 million, and the next layer could be $10 million, and then maybe there's another $10 million on top of that. So there's some strategies that you can use, one of which is asking for the umbrella excess coverage on top of the primary so that you could have access to perhaps even that full $25 million in their excess layer, or at least the original $5 million layer. So that's what we would recommend. And it's a strategy we often use, and you'll see in different contracts. Now, not everybody uses that. Some people just ask for the full $5 million in the primary commercial general liability, but you may find that some of the smaller folks that you are contracting with or asking them to provide insurance may not carry $5 million in coverage and may not be able to afford it. So that's another way to, if you bifurcate it, then you leave the negotiation for possibly the higher limits in the umbrella excess category, and the rest of it can kind of stay the same, leaving for less changes in red lines to the insurance requirements. So that's our recommendation. Is there more to the question?
Nope, I think that's it. Thank you.
Oh, good. I hope I answered it adequately. Prior to that question, and in response to what James was saying, he was talking about the importance of when local governments asking to be the additional insured on another person, on another party's insurance policy. If you're seeking additional insured coverage, asking for somebody to provide it to you so that you can be on their policy, ask for primary and non-contributory. That is part of kind of the additional coverage you want as an additional insured. You want their policy to pay first. If you're going to have access to their insurance policies and limits, you want them to pay first. You want it non-contributory so that your own insurance doesn't have to contribute. And waiver of subrogation is also a nice add-on. And James, I'm assuming that's not an issue for the city or county to be able to subrogate or waive subrogation.
No, it's actually, we recommend that our insureds always, refuse to waive subrogation if they can. Unfortunately, what we see is, they'll get into a construction contract and they'll be drafted by the architect. The city attorney may look at it, who doesn't really have expertise in the area, and misses there's a waiver of subrogation. We had a situation in the last couple of years where a city had this kind of contract, and the city carried the builder's risk coverage, but the architect and the builder screwed up in not putting a threshold, like on a community center. They had a major rain event, and it got wet inside. The flooring had to be wiped out, and we came in because we had the builder's risk coverage and paid that. But we would have liked to have been able to go back against the architect or the builder, and because they had that waiver of subrogation, we couldn't do that. The only restriction we have, which is typical, is that it has to be executed prior to the occurrence occurring. But there's not a problem with that. We just discourage our GRMA members from doing that, and it's one of those things that you really need to have somebody look at your agreements and make sure that you're covering those, because if you push back on that, you're probably going to get them to remove it. But it's something that a lot of people don't even, if they even know what it is, they're not going to push back and have it removed.
And for those of y'all that are listening in, subrogation is where the insurer has the right, after it's paid a claim on behalf of you, local government, as the named insured, and it's paid a claim maybe because you extended additional insured status to a architect or builder, they paid a claim on behalf of the builder. Now the insurance company, as under its right of subrogation, can go and recover the amounts of that claim from the architect or builder, just as the situation that James was describing. So if that right of subrogation is waived, that means neither you, local government, nor the insurer can go and recapture those funds that were paid out on behalf of the architect or engineer in that case. So it is a very important piece to understand. I think subrogation is a little bit of a confusing term, but think of it as a transfer of rights of recovery, which is how you may see it as an endorsement on the policy. It may not say subrogation, it may call it a transfer of rights of recovery. And there's a clause in the standard contract insurance policy, and the endorsement is the waiver of the transfer of rights of recovery or waiver of subrogation. So that's kind of an important thing to note, because once you've done that, that means everybody, nobody can go collect against the other for what their insurance may have paid on behalf of the other. Insurance policies often are set up with deductibles and or self-insured retentions, and it's kind of important to note the distinction between the two. A deductible is going to apply to each claim, and while the insured is responsible for paying amounts under the deductible, the insurance will pay the claim first and then go back and get the deductible amount from whoever the named insured, which would be the local government here. A self-insured retention is different. Self-insured retention means that until the self-insured retention amount, let's call it $1 million, has been paid by the named insured, so you're going to have to pay up to that $1 million. Until that amount is paid out net, insurance isn't going to cover anything. So if there's a claim that falls below that $1 million, and that means your other contracting party is self-insuring, paying for it out of their own pocket for profits. So a deductible is something that is preferable from your perspective than a self-insured retention, because insurance may never kick in and cover if the self-insured retention is really high on the other party's program. One of the things you can ask for is to have the self-insured retention noted on the certificate of insurance you receive. The deductible amount I guess it's important to know how large their deductible is, but if it's somebody that, has a large corporation, Georgia Power or something like that, maybe not quite as important. But the deductible amount, you're still going to be covered, whether they pay their deductible or not. But the self-insured retention, insurance does not even start covering the claim until the self-insured amount has been met. So it's kind of an important distinction and something that could affect you in the claims payout. These are some terms we've been talking about, and I promise you we would get to them. So what is an additional insured? Additional insured, which is offered by endorsement, provides direct access to the liability policy. That can be the commercial general liability generally, the auto liability, and the umbrella excess liability. It is not available for workers' comp. And so it's direct access to those types of insurance policies where the other party is included as an additional insured, can make a claim directly on local government's insurance policy. So if you're offering additional insured coverage to somebody, or they've required that you provide it, that means they're going to have direct access to your insurance. They can make the claim. If you're the additional insured on somebody else's policy, the same goes. You'll have direct access to their insurance. And that's what we were talking about a few minutes ago. That's the importance of having your access to be primary and non-contributory. So when we say that, also that's available by endorsement to the policy. The party agreeing to provide the primary and non-contributory insurance is agreeing to have its insurance policy pay first and without seeking contribution for other insurance policies, which may also be primary or first for payment of such claim. So when you are asking to be, or where you are requiring that you are the local government or the additional insured on the other party's insurance, also require that they provide you primary and non-contributory coverage as well. These endorsements are generally written in what we call a blanket format, which means you won't necessarily see an endorsement that says city, Georgia is an additional insured. It will say that you're included as an additional insured where required by written contract or agreement. So this would be something you want to have specifically stated within the contract that you are to be included versus named, because you won't receive an endorsement showing that you are actually named as an additional insured, but that blanket endorsement is sufficient to have those additional insured coverages extended to you. And the primary and non-contributory are usually generally drafted in a blanket manner now. That is the common practice these days, so that insurers do not have to keep issuing endorsement specific, what we call entity specific endorsements. We spoke about waiver of subrogation a moment ago. Unless there's a question, I'll just kind of move on past that. Another requirement that you'll often see is to require where you or your insurance carrier is to provide notice of cancellation or non-renewal or material change to another party within usually 30 days in writing. The policies are generally set up where if there's an endorsement that says, yeah, we'll provide notice of cancellation or non-renewal to a certificate holder or additional insured on your policy. You have to make sure that the insurance company has a list so they know who to mail it out to if your policy were to be canceled or non-renewed. The problem comes in when you're asked to provide notice for material change. Typically, material change is not defined within the contract, so who's going to determine whether the change is material or not if there's no definition? And most, in fact, rarely have I seen an endorsement. I think I've seen one in all the policies and contracts that I've looked at where the insurer has agreed that they will provide notice of material change to another party. The difficulty is in the details, what's material. The insurance company doesn't generally even provide notice to its named insured if there's changes within the policy, such as, erosion of limits or things like that. So it's a difficult one and a burdensome requirement to try to meet or satisfy, whereas the notice of cancellation or non-renewal is already part of the policy, part of the standard policy, and that can generally be met. So if you're the one reviewing, you don't want to agree to have your insurer provide notice of material change, and you don't want to have to do that either. If you were to reword it and say, well, okay, not insurance company, we local government will provide notice of material change, I highly suggest don't do that. It's a very burdensome requirement, and it's difficult to figure out what is material or not. Moving on to additional requirements that you may see. Separation of insureds. This is a standard provision within an insurance contract. You may also hear or see a request for severability of interests or cross liability. That is the same thing. So your separation of insureds clause does in fact provide severability of interests and cross liability, meaning that the ability for the additional insured and the named insured to file suit against each other and have it covered under the policy, it just won't affect the limits. And that's the clause right there, that the standard clause in the insurance services office forms, that's the clause in front of you. Another one you may see is a requirement for AM Best ratings or AM Best ratings for insurance carriers. AM Best is a third-party rating service that goes and basically determines the financial health wellness of insurance carriers. And so if there's an AM Best rating that's agreed upon between the parties, and we at Marsh, A-8 is what we recommend, nothing lower or higher. So minimum of A-8. You may have different parameters which are within your contracts, but that's our recommendation. And then you can use this as a third party way to kind of vet the insurance carrier. Oftentimes what you'll find in some older insurance provisions is where it will say that you may want to approve the other party's insurance carrier. Well, that puts the other party in a difficult situation sometimes, because they usually have, if it's a large company, they'll already have their insurance program in place. They're not going to want to make changes to one particular contract, but they're willing to agree to AM Best rating. So that is a mutual place to meet and kind of know that you're, based on the rating that you've agreed upon, that's an insurance carrier that should be acceptable to you because it meets the AM Best rating. Excuse me. So when we talk about commercial general liability, We've discussed some of these additional insurance coverages already. Additional insured coverage, waiver of subrogation, primary non-contributory. We have not talked about a per project or per location aggregate. Again, this is something that's provided by endorsement, and it's a nice endorsement. It's a nice thing to have, particularly in construction arrangements, because that means that policy is going to have specific aggregate limits that have been dedicated to a location or project. So when you see the manual and some of the draft templates, you will see that depending on the type of work that the vendor or contractor or consultant will be providing, we have asked for per project or per location limits on your behalf. And another, excuse me, another important clause or coverage that's in the standard policy, this is not by endorsement, is called contractual liability. And contractual liability is kind of the insurance for the indemnity clause. It supports indemnity. It will not cover it 100%, as I mentioned before. Any expectation that insurance is going to cover any and all of anything is wildly out there. It's just not going to happen. Insurance is not set up that way. But contractual liability, which covers for insured contracts, which are defined within the policy, includes where there's an assumption of the tort liability of another. So if in the indemnity clause, the other party has agreed to cover bodily injury, which may have incurred, and you can't get the coverage under additional insured, you've been added to the policy as additional insured, and for some reason the claim's been denied, you may get recovery as under the contractual liability coverage. Unfortunately, that's not direct access like additional insured, which is another reason for the importance of additional insured. You usually have to litigate, get a settlement or a judgment, and then seek to have impose that to get the contractual liability coverage paid by the insurance company. So circling back, additional insured coverage, that's direct access and is a better way to try to get the coverage under somebody else's policy. Commercial auto, as you will see, we have primarily the same type of things. 2 additional endorsements. These are pollution related. The MCS 90 is it's part of the highways for pollutions on the highways, and then the pollution liability. If you have anybody that's doing work for you and they may be transporting any hazardous waste or pollutants, you want to make sure you ask for these 2 additional endorsements. The rest of it is very similar to the same. Oh, one point. If you can, ask for any auto coverage or symbol 1. That's the broadest coverage. It covers hired, owned, non-owned autos, and it does provide you the broadest coverage. Ask for it. If they don't have it, they'll let you know and you can make that modification. Workers' compensation. I'm going to skip the waiver of subrogation since we've already talked about that. These are some additional endorsements that can be added to a workers' compensation. I know Georgia's got a big old coastal shoreline, so the U.S. longshoreman and harbors worker may be appropriate for work that's along the coast. The Maritime and Jones, which is for members of crews and vessels. Outer continental land shelf. Now, stopgap liability, Georgia's is not one of those monopolistic state-funded insurance for workers' comp, so that may or may not apply. If you're contracting with somebody in North Dakota, Washington, Wyoming, or Ohio, you would want to ask for stopgap employer's liability because they are monopolistic state funds and they don't have employer's liability as part of that. And note that officers are included in workers' compensation. We talked about umbrella excess and what the underlying policies are underneath it. Typically, the request is to ask to have it follow form or be at least as broad as those underlying coverages. Pollution liability is usually covering sudden and accidental losses, and you want to make sure cleanup costs are part of that. Property insurance, that again, it's the first party property covering for your property. You may have been asked to provide loss payee coverage for maybe a lien holder or mortgage holder. That's just to make sure that they get paid because they have debt on whatever that piece of property is. Professional liability errors and omissions. There's all sorts of types of errors and omissions coverage. You'll see here kind of a list, and then we talked about technology, and I guess I'm highlighting that because in the last couple of years that's become even more important. So this is often, it's designed to cover providers of technology services or products. So if somebody's designing software or re-engineering your network system or providing hardware, you want to ask for technology E&O. It usually includes cyber liability, but that can be a standalone policy, and media liability. Now, media liability is the one that's going to provide coverage for infringement of patents and trademarks and those types of things. It may not be covered under the other two portions of that. And then cyber liability is a type of insurance designed to cover consumers of technology services or products. You may or may not have PII, personally identifiable information, on some of your systems. I'm sure you do. So cyber liability is the type of insurance that'll cover if there's a breach or malicious malware attack or something in your systems and there's somehow that's released. So it'll cover you usually for providing notification, the call center, the credit monitoring, all that laundry list of things you now regularly receive notices on your alerts that says, oh, you've been part of a cyber breach. It provides that type of coverage. And then oftentimes, if you have a cyber liability and it's related to a technology product, you're covered under your cyber policy, but you have also triggered maybe an errors and omissions claim under the provider's technology errors and omission. If it's something within what they provided to you, then you may have a claim there that could in fact reimburse you in your policy. So if they didn't do it right, you may have a place to go to get paid. I think we're kind of rounding out the last of, we're running out of time too. So quickly, there's two types of coverages: occurrence, which is the more normal, and claims made policies. Your claims made policies are generally going to be your professional liability policies and your pollution liability policies. Most of the rest, commercial, general, auto, umbrella, excess, are written most commonly on an occurrence basis. You will find when they're not, and it's something you would need to know, because the difference is what triggers the coverage. A claims made policy is going to be triggered at the time the claim is made, whereas an occurrence-based policy, it's when the claim actually occurred, not when the claim is made. So you may or may not have coverage under a claims made policy for something that occurred historically, but the claim is just now surfacing and being made. So you would want to be aware of that, the type of policy that your vendor or it's being provided. And I'm going to quickly leave a couple minutes here for questions. Does anybody have any questions?
Does anyone have any questions?
Is anybody awake?
I think people are just so nervous to ask questions. Anybody?
It's such a lively topic. I understand that.
It is a tough one to cover. Well, Nancy, thank you so much for covering the topic. It is extremely valuable. Here's a question. To clarify, it is okay to have private company as an additional?
As an additional insured?
I guess. Can you clarify that, Christopher? Question?
James, you were speaking of Georgia-specific preferences. I am speaking from a broader perspective. My answer would be yes, that's acceptable as long as you understand that you're making your insurance limits available to them, that if there's a claim and you may, as local government, have at least part fault in that claim, then you might be providing your insurance limits to them. James, do you have a different answer?
Here's a little bit, before you answer, James, here's a little bit more of the question. When the city does events on private property, they ask us to be an additional insured on ours.
It is permissible for a city or county to contract to provide insurance coverage to a private party. The limitation I was speaking of had to do with the interlocal risk management agency statute. It's not clear to me under the enabling legislation for GRMA and ACCG IRMA that those pools can indemnify or can name private parties as additional insureds under these enabling legislation of these pooling statutes. But a city or county in Georgia could contract, and commit itself to add a party, if it had, commercial insurance, there wouldn't be a problem. I don't know that it would be enforceable, and I believe both pools try to resist that to the extent we can, so we don't end up in the situation where we're having to use these public pools to insure private parties.
So I guess the answer is if you have a commercial insurance program, that is acceptable, and it's quite honestly a common request in business transactions to include a party or to ask to be included as additional insured on another's policy. But it sounds to me that if you're using the pooled programs there in Georgia that are available, that may not be something that's possible based on the way that they are structured under the enabling statutes.
Correct. And we don't want to be in the position, if there's litigation, of having to defend not just the city or the county and the officers and employees of those local governments, but also, some private entities who perhaps should have their own insurance. We just don't want to be in the position of having to do that. And I'm not sure. We've got a debate as to whether that's actually a legal obligation of the pools in Georgia. But if push comes to shove with a significant, a third party that's got significant bargaining power, you may have to commit to do that and put the language to the extent permitted by law. And
James, here's a question specifically for you. Can James speak to when you do versus when you don't want to have a waiver of subrogation? If I understand correctly, the city wants it when we are named as an additional insured on another's insurance, but we don't want it when when we have another named as the additional insured on our insurance.
When we carry the insurance, we want the other party to waive subrogation. When the other party, when we have to carry the insurance, we do not want a waiver of subrogation. Does that make sense? We want to, if we're having to carry the insurance, like a builder's risk policy I was discussing, which is sort of a specialized policy for construction projects. If there's a loss and, the city or county is having to carry that builder's risk coverage, you want to be able to go back against the contractor or the architect or whoever screwed up if you can, so that the economic fallout doesn't come back on, the city or county. But if the other party is carrying the insurance and they end up paying the loss, we like to have a waiver of subrogation, because then they can't sue the city or county and come back against our insurance. And this is something that's specific to Georgia too, that's a quirk of the case law here. Counties have much stronger immunity. Even if they have insurance, they retain their sovereign immunity on state law claims. Cities do not. If a city has insurance, pretty much it's just like a private party up to the limits of coverage. So you like to protect the city from losses by making sure that there is a waiver of subrogation if you can get the other party to agree to it. But that's again another reason why you'd want to have, go to your broker, go to a lawyer that's familiar with these types of issues, and make sure that you hammer those out, particularly on big construction projects where you could have significant losses.
James, in my experience, waiver of subrogation, people typically want it reciprocal. How do you find that?
I would probably, that's typically what you get in most contracting situations. You feel kind of like a jerk to not agree to a mutual provision. So I would probably, I'd probably rather go ahead and agree to it. And it's not uncommon in construction projects to have it so that, you know, you go ahead and decide who's going to bear the risk of loss when you decide who carries the insurance, and then nobody has to deal with litigation down the line. You go ahead and make that decision on the front end. But so typically it's mutual. If the other side wants it to be mutual, you really would feel like you're sort of acting like a jerk if you didn't go ahead and agree to that.
Okay.
So here's another question. As to the written notice of cancellation of policies, are clauses that provide for the notice to be certified mail enforceable?
They're not realistic. Every endorsement that I've seen and more I've seen in recent years, that the notice, if the insurance company is going to even provide it, is going to be by email. I wouldn't make that a breach of contract. I don't think that it wasn't provided by certified mail. When we're reviewing contracts, and we do for a lot of clients, this is, you know, what I do, we would strike certified mail because there's certain endorsements that will not. It's going to maybe regular mail, email, something like that. And we would just put written by written, you know, written notice. But is it enforceable? I don't know. You're not contracting with the insurance company. That's something I guess I should back up and say. You're contracting with a party that has an insurance contract. That party can't make the insurance company provide notice by certified mail either. So it may not be enforceable.
Some good interactions, some good questions. Anybody else have any questions? Well, that sounds good. James, Nancy, any last comments?
I hope I see everybody again tomorrow. Just want to reiterate the importance of having these insurance sections reviewed before the contract signed. We'll get into a little bit more details on some things we touched on today, and hope you'll be here on Thursday as well, where we actually have some tips and tricks that you can start performing the insurance review yourselves.
James, any comments?
Appreciate the questions, like listening to Nancy, and I look forward to seeing you guys tomorrow.
Well, thank you both. Really appreciate it. As both Nancy and James have said, we do have a webinar tomorrow at the same time and Thursday at the same time. So look forward to seeing each of you there. As I said at the beginning of the webinar, when this series completes, I will be sending the PowerPoint presentation along with links to the recordings, along with the contracts manuals to all those that registered. Thank you so much and have a good rest of the day.
Thank you, everyone.
Thanks.